Immediately after World War I, when the United States of America relished in the victory over the Central Powers, back home the nation struggled with forces from within. After the Russian Revolution of 1917, the United States Department of Justice took a stringent view toward Reds or any other anarchists who may have permeated the borders of the country. Mass immigration to the country had been nothing novel, but this time the enemies of the Republic seemed to appear at the country's doorstep at the most inopportune times. In the early 1920s, an event occurred that tried the patience of the melting pot nation and demonstrated that nativists cared less for justice than they did for maintaining America for Americans. Two comrades, born in small towns in both the Puglia region and Piemonte region in Italy, emigrated to the land of opportunity known as the United States. Both of them arrived in 1908, but they did not meet until 1917, when they began thinking in political terms. The men were followers of Luigi Gallieni, an Italian anarchist who advocated revolutionary violence, including bombings and assassinations. It was the start of this career and misguided loyalty that, by 1927, brought both men full circle in their new country. But they both became infamous for a heinous crime that, to this day, remains a mystery in legal history. Ferdinando Nicola Sacco was born on April 22, 1891. Sacco became a shoemaker in his home village of Terramaggiore, Foggia Province, Puglia Regione, Italy, and migrated to the United States in 1908 at the age of 17. Also at this time, Bartolomeo Vanzetti grew up as a fishmonger in Villafoletto, Cuneo Province, Piemonte region, Italy, and then emigrated to the United States, arriving at approximately the same time as Sacco. When the two young men finally made it to the New World, they became disillusioned and began following an Italian anarchist named Luigi Gallieni. Sacco and Vanzetti attended meetings and never really sought to put any of the principles in practice, but both felt as though they were destined to great things. They just did not know how they were going to accomplish this greatness. On the afternoon of April 15, 1920, at approximately 3 p.m., a paymaster named Parmenter and his guard, a man named Berardelli, were carrying a factory payroll of $15,776 through the main street of South Braintree, Massachusetts, a small industrial town south of Boston. Two men standing by the fence of the shoe factory brandished weapons and opened fire as the paymaster and his guard made it up to the men. The gunman snatched up the cash boxes dropped by the mortally wounded pair and jumped into a waiting automobile. The total of 4 men sped away and lost their pursuers. The getaway car was later discovered in some woods close to the crime scene. At first, the crime, although there were 2 brutal deaths, did not gain much coverage in the press. But later, as the dragnet widened, 2 Italian immigrants fell into a police trap. Along the same lines as the Braintree robbery, police also investigated a crime with the same modus operandi in the small nearby town of Bridgewater, Massachusetts. Authorities literally arrested the two for 2 reasons. Number 1, they were Italian immigrants, and number 2, they considered themselves anarchists. On May 5, 1920, Nicola Sacco and Bartolomeo Vanzetti were arrested as they were in Braintree at the time of the robbery, and when the police arrested them, they were both carrying firearms. While under interrogation, both men lied, and therefore the authorities believed that they were the culprits to the robbery and the senseless murders. Eventually, the two would be indicted for the Braintree crimes, and thus began one of the most contentious political trials in American history. Vanzetti was also held for an earlier robbery, the one in Bridgewater, Massachusetts, and when the trials commenced, authorities tried him first, which included the lesser Bridgewater robbery. The trial of the two began on May 21, 1921 at Dedham, Norfolk County. Part of the jury was specially selected by the sheriff's deputies from Masonic gatherings and from persons whom deputies deemed representative citizens, substantial, and intelligent. The presiding judge was Webster Thayer of Worcester. Since there were some difficulties with the translation of the court proceedings, an interpreter had to be engaged for the defendants. The question for the court was not that the murders had occurred. It was whether Sacco and Vanzetti were the true culprits. 59 witnesses testified for the Commonwealth of Massachusetts and 99 for the defense. The prosecution forwarded a theory that Sacco did the actual shooting, while Vanzetti sat in the car as one of the conspirators to the murders. Witnesses stated that they saw both of the defendants in South Braintree on the morning of the robbery murders, and they recognized Sacco as the man who shot the security guard, Baradelli, and saw the alleged assailant escape into a car. One of the bullets removed from the security guard's body matched the weapon that Sacco possessed at the time of his arrest. The prosecution relied heavily on the behavior of the two defendants after their arrest. The prosecution stressed the consciousness of guilt expressed by Sacco and Vanzetti that proved them responsible for the Braintree robbery and murders. The defense countered the prosecution witnesses with witnesses of their own. Most of the defense witnesses countered the testimony of the prosecution by stating that they witnessed the defendants in different locations on the day of the robbery other than Braintree. In fact, it was proven that Sacco visited the Italian consulate the day during the time of the robbery and the murders. One of the chief reliants of the prosecution fell to a Mary Splain, who claimed to have seen Sacco in the getaway car after hearing the gunshots that killed Parmenter and Baradelli. The office window was approximately 60 to 80 feet from where Sacco allegedly entered the vehicle after the crime. Splain testified,
"The man that appeared between the back of the front seat and the back seat was a man slightly taller than the witness. He weighed possibly from 140 to 145 pounds. He was a muscular and active-looking man. His left hand was a good-sized hand, a hand that denoted strength."
40 days after the crime, Splain was unable to identify Sacco as being at the scene. Yet after a year to think about it, she came up with a positive identification at the trial for their lives. The defense then produced a psychologist, Dr. Morton Prince from Harvard University, who discounted Splain's testimony. "I do not hesitate to say that the star witness for the government testified honestly, though, no doubt, to what was psychologically impossible. Miss Splain testified, though she had only seen Sacco at the time of the shooting from a distance of about 60 feet for from 1.5 to 3 seconds in a motor car going at an increased rate of speed at about 15 to 18 miles an hour. That she saw, and at the end of a year she remembered and described 16 different details of his person, even to the size of his hand, the length of his hair as being between 2 and 2.5 inches long, and the shade of his eyebrows. Such perception and memory under such conditions can be easily proved to be psychologically impossible. Every psychologist knows that, so does Houdini. And that shall we think of the animus and honesty of the state that introduces such testimony to convict, knowing that the jury is too ignorant to disbelieve?" Other witnesses could not positively identify Sacco as the man that other witnesses stated was the man they saw in the getaway car. The prosecution's case seemed to fall apart as the case progressed. The trial took 7 weeks, and on July 14, 1921, the jury found Sacco and Vanzetti guilty of murder in the first degree. The jury believed that the defendants exhibited a consciousness of guilt, which meant that Sacco and Vanzetti's conduct after the 15th of April was the conduct of murderers. Jurors drew inferences from the behavior of the defendants the night of their arrest. The defendants had no prior criminal experience, and yet the circumstantial evidence convicted the men and sentenced them to death. Innocent men, it can be argued, do not lie when they are arrested and then detained by the police. The Boston area, at the time of the alleged crime, was one of the centers of lawlessness and hysteria. It appeared that public opinion and preconceived notions of guilt actually convicted Sacco and Vanzetti. At the time, citizens became very concerned with the anarchic behavior of immigrants that believed in the same ideology as the suspects. Most Americans were anti-immigrant based upon that very reason. The U.S. Department of Justice had launched a concentrated campaign for the arrest and deportation of immigrants who exhibited any flair for anarchy. In 1917, 3 years before the Braintree robbery, the DOJ sought to rid the country of all things that may have been suspected or influenced by the communist revolution in Russia by deporting all those suspected of those ties. Most of these anarchists found themselves deported out of the country for supporting a violent overthrow of the U.S. government. Sacco and Vanzetti were known associates with leading radicals and had been on a list compiled by the Department of Justice, and because they were also draft dodgers, they became equally targeted by the general public. To find an impartial jury, mostly within this country, that could try these two men fairly was almost impossible. During the trial, Sacco and Vanzetti recounted their movements on April 15th, the day of the robbery and murders, and accounted for their questionable actions on May 5th, the day of their arrests. The prosecution made the case for their lack of patriotism and their flight to Mexico to evade the draft during World War I. The prosecution consistently played on the nationalism of the jury when it came to convicting the two radicals for a crime that they may or may not have committed. Even though there were several convictions that were overturned due to patriotic fervor rather than evidence that proved the guilt of the defendant throughout the courts of the United States, the judge in the Sacco and Vanzetti case allowed the district attorney to opine and use emotions of the jury rather than the proper procedural presentation of his case and evidence, further relying on inferences and innuendo rather than exculpatory evidence to the contrary. After the trial, defense attorneys filed an appeal, and on May 12, 1926, the Massachusetts Supreme Court heard the arguments regarding the assignments of error. The court ruled that Judge Thayer, the trial judge, made no mistakes in his rulings. The guilt or innocence of the defendants was not retried in the Supreme Court. Different from other jurisdictions, the Massachusetts Supreme Court would have gone beyond their scope of review had they examined the facts that resulted in the guilty verdict. What is reviewed is the conduct of the trial judge and whether he violated the rules of court, not whether any procedural malfeasance that occurred had any bearing on the verdict itself. The justices ruled that Judge Thayer did not abuse his discretion, and therefore his ruling in the lower court must stand. Even though the Massachusetts Supreme Court found no assignments of error on the part of the trial judge, defense counsel maintained that the circumstances of the case all pointed away from Sacco and Vanzetti. However, the deaths of Parmenter and Berardelli remained unexplained. But just at the time that the Supreme Court made their ruling, the defense produced additional evidence that not only Sacco and Vanzetti did not commit the murders, but also, positively, a well-known gang of professional criminals committed the robbery and the murder. The defense moved for a new trial, stating that because of a new body of evidence demonstrating others were responsible for the crime. Someone who was in the same prison with Sacco sent him a message through the prison system that he, a Portuguese man named Celestino Medeiros, was responsible for the murders in Braintree, Massachusetts. Just because someone else confessed to the crime does not necessarily mean that he was culpable for those crimes. Additionally, prosecuting attorneys should be wary of any jailhouse confessions, especially during such a high-profile case such as this one. However, the new evidence was not included within the Medeiros confession. When the defense counsel investigated Medeiros' confession, they discovered that the young man tried to apprise Sacco several times that he was responsible for the Braintree crimes. In 1920, Medeiros was 18 years old and living in Providence, Rhode Island. He already had a criminal record and was associated with a known Italian gang at the time who sought their fortunes in robbing freight cars. One night in April, when the gang were drinking at a local saloon, they came up with an idea to rob a payroll in Braintree, Massachusetts, just a short car ride away. A holdup appeared to be a new form of gaining money, according to Medeiros. The leaders of the gang gave Medeiros one simple assignment: stay in the car with the revolver and then hold back the crowd should one amass as a result of any calls for assistance. The intended robbers used 2 cars to prevent identification. When the time came, the shooting was perfected by the 2 oldest Italians. The rest of the assailants stayed behind near the automobile. After the crime had been committed, the car drove near the robbers, they got into the vehicle, and the vehicle sped away. Later, the men planned to meet at a saloon in Providence to split the booty from their robbery. Medeiros never acknowledged whether this part of the plan was perfected, and he steadfastly refused to identify the other men in on the alleged robbery and murders. Moreover, when asked questions about the other assailants, Medeiros either excluded certain facts or outright lied. What corroborated Medeiros' version of the story was that 2 witnesses at the Sacco Vanzetti trial testified that a man matching the description of Joe Morelli, the leader of the gang, was allegedly seen shooting Parmenter and Berardelli, and another man identified as Mancini was also at the scene of the shooting. With the new evidence, it appeared that the defense had built a convincing case that a new trial should be granted for Sacco and Vanzetti. However, Medeiros' confession underwent the utmost of scrutiny for the main reason that a man facing the death penalty for one crime and then confessing to another crime, it is obvious with the same weight as the predicate felony, it must be investigated thoroughly to secure that it is free from suspicion and trustworthy. Investigators questioned Medeiros' partner in the crime that he stood convicted and sentenced to death. Medeiros seemed to draw on his alleged experience with the Braintree robbery before the bank robbery that he stood convicted and sentenced. Medeiros' confession seemed to flaunt logic. Why would one man confess to a murder while facing the death penalty for another murder, unless there was something in it for him, specifically money? Medeiros claimed that his motivation surfaced when Sacco's wife and children came to the prison for a visit. He felt sorry for the family and decided, since he had nothing to lose at this point, he would make sure that Sacco would go free. Even discounting Medeiros' confession, the evidence used to convict Sacco and Vanzetti seemed circumstantial, to say the least. It appeared that the passions of the jury regarding immigrants and anarchists proved to be the deciding factor. When considering the motion for Sacco and Vanzetti's new trial, it was not incumbent upon Judge Thayer to determine the guilt of the Morelli gang and Medeiros, or the innocence of Sacco and Vanzetti. The jurist merely had to ascertain whether the new information fit for a new jury's judgment. In short, could an honest jury consider the new evidence and come to a different conclusion that the jury did from the initial trial? Judge Thayer ruled no. A new jury could not reach a different conclusion even considering the new evidence. Later analysis of Judge Thayer's opinion represents misquotations, misstatements of fact, suppressions, and truth mutilations. It became readily apparent that Judge Thayer allowed his personal feelings about the defendants to permeate his decision to not grant the new trial. The judge's opinion for the motion for new trial confirmed historians' assertions that the verdict for the original trial was not just and fair. A second trial took place with the same verdict and the same sentence as the first trial. The defendants faced Judge Thayer once more, and it seemed that the new evidence presented proved inconsequential. The defense formulated an attack against the federal government regarding the political affiliations that the defendants exhibited. This angered Judge Thayer, and it appeared that he remained partial to the prosecution's case. The defense appealed once more to the Supreme Judicial Court, and according to the cited case, presented their arguments on January 11th through the 13th, 1927. The defendants' various assignments of error were discounted, ruling that the trial court did not abuse its discretion when it denied the various motions for new trials. Judge Thayer again heard arguments for a new trial and ruled that the responsibility for the conviction rested sole with the jury's determination of guilt. The court has absolutely nothing to do with that question. In conclusion, Thayer sentenced both Sacco and Vanzetti to suffer the punishment of death by the passage of current of electricity through their bodies. Last-minute appeals for clemency were then submitted to the governor of Massachusetts, Alvan T. Fuller. Fuller organized an advisory committee in order to examine the trial procedure and whether the verdict reached was just and according to the rule of law. After 2 weeks of hearing witnesses and considering the evidence, the committee determined that the trial had been conducted in a fair manner and a new trial would not be warranted. Although there was general acceptance as to the verdicts and sentences, several compatriots of the convicted men protested very loudly. In fact, they resorted to some dastardly tactics with which to express their disappointment. On August 15, 1927, with the executions scheduled for midnight on the 22nd, a bomb exploded at the home of one of the jurors from the second trial. On August 21, 1927, more than 20,000 protesters assembled on the Boston Common to attempt to save the lives of Sacco and Vanzetti. On their last day, both Sacco and Vanzetti refused a priest to grant them absolution. Their attorney, William Thompson, requested that Vanzetti release a statement against any violence that may occur as a result of his and Sacco's executions. They also discussed forgiving their enemies. Celestino Medeiros, whose execution had been delayed just in case he had to testify at another Sacco and Vanzetti trial, was slated to go first to the electric chair, followed by Sacco. Sacco went to the chair quietly, but once he was strapped in, he yelled, "Viva l'anarchia!" and "Farewell, mia madre." Following Sacco's death, Vanzetti made his way to the execution chamber after shaking hands with the prison guards and thanking them for their kind treatment. He then read a statement where he proclaimed his innocence. Then he finally said, "I wish to forgive some people for what they are now doing to me." Following the executions, violent protests occurred in Geneva, Switzerland, London, England, Paris, France, Amsterdam, the Netherlands, and Tokyo, Japan. In South America, workers' strikes forced the closing of several factories. 3 protesters died in Germany, and protesters in South America burned an American flag outside of the embassy. At the funeral parlor in Boston's North End, over 10,000 mourners filed past the caskets of Sacco and Vanzetti for over 2 days. A wreath appeared that stated in Italian, "Aspettando l'ora di vendetta," which meant, "awaiting the hour of vengeance." On April 28, 1927, a 2-hour processional made its way through the streets of Boston. At one point during the processional, police and the mourners clashed. The executed men were then cremated, with Sacco's ashes being transported to Terra Maggiore, where they remain today, under a monument in that city erected in 1998. Vanzetti's ashes were buried near his mother in Villa Falletto. Even after their executions, anarchists continued to protest their deaths, but the bell had already been rung. History continued to question whether the 2 men were truly guilty, or were they the victims of a xenophobic society willing to sacrifice lives for the status quo. Later investigations proved the original evidence to be compelling as to the defendant's guilt. In October 1961, the ballistics tests were run with improved technology using Sacco's automatic weapon. The results confirmed that the bullet that killed Berardelli in 1920 was fired from Sacco's pistol. Subsequent tests determined the same result. Over the years, continued critics have stated that several witnesses to the crime insisted that the gunman, alleged to be Sacco, fired 4 bullets into Berardelli. In 1927, the defense raised the suspicion that the fatal bullet had been planted by the police. A later commission stated in 1985 that this was just an act of desperation on the part of the defense. In 1973, a former mobster published a confession by Frank Butsy Morelli, who stated that the mob whacked Parmenter and Berardelli, and Sacco and Vanzetti took it on the chin. One of the members of the Sacco and Vanzetti Defense Committee admitted to his son in later years that they knew Sacco was guilty and that Vanzetti was innocent as far as the actual participation in the killing. In 1977, Massachusetts Governor Michael Dukakis asked the Massachusetts Legal Counsel to determine, quote, whether there were substantial grounds for believing, at least in the light of the legal standards of today, that Sacco and Vanzetti were unfairly convicted and executed, end quote. The report submitted to the governor doubted that the two were convicted and sentenced fairly. Based on the recommendations of the investigating committee, Governor Dukakis declared on August 23, 1977, the 50th anniversary of their execution, to be Sacco and Vanzetti Memorial Day. The proclamation, issued in English and Italian, in that any disgrace should be permanently removed from their names. However, he did not offer, nor did he perfect a pardon for the two men. This would have admitted some guilt, yet he did not stress that they were innocent either. Although the Massachusetts Senate sought to censure the governor for these actions, Governor Dukakis stated later that he should have reached out to the families of the victims as well. If you enjoyed this program, please hit like, subscribe, and hit the bell to notify you of any upcoming episodes. And we really would appreciate your support at Facebook, Twitter. We're on Buy Me a Cup of Coffee and PayPal, and I will leave the links below. Until next time.